My name is Michael Busby. I am a Harris County and Fort Bend County divorce attorney. Alimony and spousal support in Texas. Spousal maintenance is defined in the Texas Family Code as an award in a suit for a dissolution of marriage of periodic payments from the future income of one spouse for the support of the other spouse. Alimony is a term that is used to refer to a contractual agreement between spouses for future support of one of the spouses. Contractual alimony can be a useful tool in negotiating a settlement between divorcing spouses that will allow the receiving party to receive income and provide tax benefits to the paying party. The eligibility of spousal support, a party seeking spousal support, will be determined on several factors. The ability for the receiving party to meet their minimum reasonable needs is the first standard. Family violence that has occurred in the last 2 years before the suit is filed or that occurs while the suit is pending. The ability to earn enough to provide for the minimum reasonable needs because of a incapacitating physical or mental disability. Also, if the marriage is over 10 years, then you need not show that there has been family violence. A marriage under 10 years, you will need to show some form of family violence. If you have a child of the relationship and that child of any age who requires substantial care and personal supervision because of a physical and mental disability, and then the spouse requesting is unable to provide for their minimum reasonable needs because of the care that is given to that child. The duration of maintenance, except in disability situations. In a disability situation, you can ask for maintenance on into perpetuity, which is until a statutory reason to terminate the spousal maintenance would apply, such as death of the parties or remarriage. If the marriage is under 10 years and family violence has been proven, then you can get up to 5 years. If the marriage is between 10 and 20 years, your maximum duration is 5 years. 20 and 30 years, the maximum duration is 7 years. And 30 years or more, the maximum duration is 10 years. The method used to determine the child support, the court will look at a maximum award of $5,000 per month or 20% of the paying spouse's average monthly gross income, whichever is less. Gross income for spousal support purposes is a little different than child support. What gross income includes for purposes of spousal support is 100% of all wage and salaried income and any other compensation for personal services, interest, dividend, royalty, and self-employment income, net rental income, defined as rent after deducting operating expenses and mortgage payments, but not including non-cash items, all other income actually received, including severance pay, retirement benefits, interest income from notes regardless of the source, gifts, prizes, maintenance, and alimony received. Gross income does not include return of principal or capital, accounts receivable, benefits paid in accordance with federal public assistance programs, benefits paid in accordance with temporary assistance for a needy families program, payments for foster care of a child, Department of Veterans Affairs service-connected disability compensation, supplemental Social Security income, Social Security benefits and disability benefits, workers' compensation benefits. The factors that the court will look at to determine whether or not one may be eligible for maintenance will be each spouse's ability to provide for their minimum reasonable needs, the education and employment skills of both spouses, the time necessary to acquire education or training to enable the supportive spouse to earn enough income to become financially independent, the duration of the marriage, the age, employment history, earning ability, physical and emotional condition of the spouse who is seeking maintenance. If there's a child of the relationship, the ability for each spouse to meet the needs of that child while also paying child support, whether either spouse has wasted, concealed, destroyed, or improperly disposed of any community property, whether each spouse has contributed to the other spouse's education, training, or increased earning power during the marriage, the property both spouses brought into the marriage, any contributions of a spouse as a homemaker, marital misconduct, which is usually seen as adultery and cruel treatment by either spouse during the marriage, any history of family violence. The spousal support statutorily will terminate regardless of the duration on the death of either of the former spouses, the remarriage of the receiving spouse, and then the receiving spouse's cohabitation in a conjugal relationship with a new lover. So if the receiving spouse were to not get married, but to continuously reside in the same abode with a new lover, then that is grounds to petition the court to terminate the spousal maintenance obligation. The alimony would terminate based on the contract. Alimony is contractual in nature and is not maintenance. And so under the terms of whatever contract you negotiate, that would provide for termination of your alimony support payments. My name is Michael Busby. Please like and subscribe. Thank you.